Good morning. I am Federica D'Alessandra, a British Academy Global Innovation Fellow with the Global Order and Institutions Program at the Carnegie Endowment for International Peace. It is my great pleasure to welcome you to this virtual panel discussion on what we might expect from the second Trump administration when it comes to accountability for mass atrocities and what role the US might play on the global criminal justice issues moving forward. A special welcome to our three panelists, each of whom has had an eminently distinguished career in both government and law, including having all served as the State Department's ambassador at large in charge of the Office for War Crimes and Global Accountability, spanning 3 of the last 5 administrations. More precisely, Ambassador Pierre Richard Prosper was appointed by President George W. Bush and served as U.S. Ambassador at Large for war crimes issues from 2001 to 2005. Ambassador Clint Williamson served as his successor from 2006 to 2009 during both the Bush and Obama administrations, and Ambassador Todd Buchwald serving as U.S. Ambassador at Large for Global Criminal Justice, as the position is now called, from December 2015 through July 2017. As with many other policy areas, the outcome of the U.S. presidential election will likely introduce a new chapter in American foreign policy and reshape the U.S. approach to several issues, including the defense of human rights and the pursuit of accountability for the most serious international crimes. The United States has a long exercised leadership in both of these issues, dating back, in fact, to the end of the Second World War with the Nuremberg and Tokyo tribunals, which the United States government was instrumental in setting up together with its allies to punish the most responsible officials in Nazi Germany and Imperial Japan for their horrific war crime atrocities. The United States has also played a decisive role in reviving international justice efforts once the Cold War ended, as unspeakable war crimes engulfed the former Yugoslavia, and eventually in 1994, a genocide also swept Rwanda. President Bill Clinton and his administration played a crucial role in the establishment of the United Nations International Criminal Tribunals for the former Yugoslavia and for Rwanda, and also established at that time the Office of War Crimes Issues within the State Department. But U.S. support for global justice efforts has not been limited to this. While no country, of course, has a perfect record on accountability, the United States has provided substantial assistance to a range of other hybrid, regional, internationalized, and domestic mechanisms to ensure accountability to perpetrators and justice for victims of international crimes. And this includes backing the establishment of and also helping to ensure adequate funding for the Special Court for Sierra Leone, the Extraordinary Chambers in the Courts of Cambodia, the Special Tribunal for Lebanon, the Kosovo Specialist Chambers, and the Extraordinary African Chambers, as well as specialized chambers, mobile courts, and a new breed of dedicated investigative mechanisms at both the international and domestic levels, including to support accountability for international crimes in Syria, Myanmar, Libya, South Sudan, and countless other contemporary crises where civilians' life is at risk. That includes, of course, Ukraine, where the United States has supported international crimes investigations and prosecutions through both domestic and international mechanisms, to include support for the establishment of a special aggression tribunal, which Ukraine has requested and which remains under discussion. In fact, I would say that most international justice institutions have not only benefited of a strong institutional, financial, and operational support from the United States, but also from the contributions of American lawyers and judges, including in key leadership positions. The United States also actively participated in the negotiations for the establishment of the International Criminal Court, or ICC, as we will refer to it in the course of this discussion, which today, of course, exists and sits in The Hague and has 124 states parties, including many U.S. allies and partners in all regions. Many U.S. adversaries, however, including Russia, China, Iran, are not members of the court, and neither are the United States nor Israel for that matters. And that's because despite significant U.S. contributions to the substantive provisions of the treaty that established the court, The court's final jurisdictional framework contained provisions that were highly problematic for the US government, particularly provisions, but not exclusively, the particularly provisions allowing the assertion of jurisdiction over nationals of states that are not parties to the court, such as will be the case for American and Israeli citizens. For this reason, the US relationship with the ICC in particular has been quite rocky from the start. President George W. Bush, for example, initially pursued a confrontational approach toward the court, particularly this during his first term. But this was nonetheless tempered somewhat in the second term, resulting in US support for the 2005 UN Security Council referral of the situation in Darfur to the ICC. Relationships did improve significantly under both the Obama and Biden administrations, who pursued an approach of constructive engagement with the court, where its activities aligned with US interests, including but not limited to the ICC investigation into Russian war crimes in Ukraine, which has also enjoyed broad congressional support, including by many, on a bipartisan basis, but many lawmakers in key leadership positions. This support has, however, all but evaporated in the wake of the ICC's decision to pursue arrest warrants against Israeli Prime Minister Benjamin Netanyahu and former Defense Minister Yoav Gallant for what the court alleges are Israeli war crimes in relation to the prosecution of the ongoing war in Gaza. Alongside also seeking arrest warrants against now deceased Hamas leaders Yahya Sinwar, Ismail Haniyeh, and Muhammad Deif, masterminds of the horrific October 7 attacks for their war crimes and crimes against humanity against Israeli citizens. As we will have an opportunity to discuss further, the move is obviously drawn condemnation across all branches of the US government and resulted in a sanction bill, which was passed by the House of Representatives and is, I believe, still currently before the Senate. The bill is in many ways reminiscent of sanctions that had been previously imposed by the first Trump administration, which were withdrawn by President Biden, in part because they had led to significant issues, which we will discuss in further detail, including, of course, outcry among many US allies who are, in fact, members of the court. The sanctions imposed by the first Trump administration were, in fact, the culmination of the most significant period of tension in US-ICC relationships, in which the administration pursued a policy of maximum pressure towards the court. But beyond this acrimony towards the ICC, the Trump administration also supported broader accountability issues through various other initiatives, which include support for holding ISIS accountable, condemning various regimes, including Syria and Iran, among many others, for the human rights violations, and imposing sanctions on the Chinese Communist Party over its treatment of the Uyghurs and other Turkish minorities in Xinjiang following a genocide determination by Secretary of State Mike Pompeo. So against this backdrop of divergent approaches, competing priorities, and of course, complex US-ICC relations, I'd like to turn to our panel for their reaction and contributions. Once again, thank you for being with us. And we'll start with you, Ambassador Prosper. I'd like to ask you, why is it that international accountability, global criminal justice is so important in today's world for the global rule of law? And how did it become such a top foreign policy issue?
Great. Well, thank you, Frederica, for having me. It's good to be here with my my colleagues. Let's begin by talking about exactly what you just asked. Why is it important, and why has it been important for the United States? I think, and this is important because this will help guide the future. For the United States, the issue of accountability historically has been an issue of obviously the human rights aspect to it, but primarily because of peace and stability. And I think we need to keep that in mind, that the international system was created in a way to help address the breach of peace and stability, peace and security at the international level. When we look at, obviously we can look at Nuremberg, which was the victors created the court in response to the Holocaust. But as we move forward into the 1990s, the response for the former Yugoslavia and Rwanda was not simply a pure pursuit of accountability, a pure pursuit of justice, in a sense, in order to make us feel good about ourselves. It was really a pursuit of not only obviously establishing accountability, but viewing it as a way of stabilizing the world, bringing some sort of peace and stability. So what we have now is we've moved through these various international systems with that goal in mind. But I think, and we can discuss this as we go through, I think as we have progressed in time, the issue has become a little bit diluted, in a sense, in that we have forgotten about the peace and stability aspect and have only been pursuing what I'll call the justice aspect. I mean, there's much more that I can get into in this, but I think I would rather, maybe I know we talked about me giving a longer set of remarks, but maybe we can have a discussion amongst a group on this particular point, because it will really dictate how we go forward, what is expected or what should the Trump administration do, and more importantly, what should the rest of the world do? Because we are always looking to the United States to be a leader or an anchor on this issue, but it really takes an international coalition to look at this, and then we can address the questions of where all this fits in the international order. So let me stop there and allow my colleagues to respond.
Thank you, Ambassador Prosper. Perhaps on the heels of that, we'll circle back on that, but I'll put the question out there so that maybe you can start thinking about it if you're willing to address it. As I was mentioning in my opening remarks, administration of President Bush, under which you served, initially pursued, essentially changed course over the course of 2 terms in terms of how it saw the ICC and the support that eventually resulted in the Security Council referral for the situation in Darfur. And I'm curious if you might help us think through what that evolution might have looked like and why the administration might have changed that perspective. But let's circle back on that and turn to Ambassador Buchwald first to see if you'd like to add your thoughts on this, and particularly, again, we were mentioning in the opening that one of the biggest issues that the U.S. Currently faces, insofar as the ICC in particular is concerned, is this question of the arrest warrants. But beyond that, dovetailing on the point Ambassador Prosper were raising, the need to essentially work through coalitions to support global accountability. This is something that you've emphasized in the past, specifically when you chaired the American Society of International Law Task Force, Presidential Task Force on U.S.-ACC relations and what options for engagement might look like for the incoming administration at the time, which was the Biden administration. So I'd love for you to expand on either point at this stage.
So thank you, Federica. It's great to see Clint and Pierre, and I agree strongly with everything Pierre said. When I think about these issues now, I do think back to 2020 when we were doing the task force. We worked with both Pierre and Clint, obviously. And the one of the basic premises of the task force's work in its report was that, for better or worse, the U.S. has cross-cutting interests that pointed in different directions at different times. So, for example, for better or worse, there is an interest, and it's stronger in some parts of the government than others, but it's everywhere. There is an interest in protecting U.S. troops from foreign jurisdiction, and it's inescapable. And it's not made up for the ICC. If you trace it back, it goes back to World War II, and it's been sort of consistent. And then the ICC presents the question of how we should deal with that in the face of the ICC. And it's also true that there are, some in the government who have concerns about the way that the pursuit of justice might interfere with peace negotiations and so forth. So these kind of considerations lead the U.S. to be sort of cautious about the ICC. But on the other hand, as Pierre says, it's also true that the U.S. has a very strong interest, and it's both moral and security interest in accountability. And there is this strong, and has been a strong resonance for it in the U.S. people, in the body politic. And we saw it in Rwanda, we saw it in the response to Yugoslavia. I remember my example always was, Yugoslavia was sort of the formative years of my time in the State Department. The example always was when a bomb goes off in the marketplace in Sarajevo, the American people are watching on television saying, those are bad people, they need to be punished. That's a true reaction. So there's both a moral and a security interest, as Pierre says, and there's also an interest in a more general interest in working. The policy towards the ICC doesn't exist in isolation. It's part of a broader policy of working with international partners, working with our allies, working with international institutions, and the ICC policy has to somehow sort of fit into that. Because there are so many cross-cutting issues and so many cross-cutting interests, the policy towards the ICC at any one time can depend upon what else is front and center at any one time. So, for example, your example, Frederica, your example here about Darfur, right? When there was strong opposition in the early Bush years to the ICC, was very deeply felt in a lot of places. But when Darfur happened and all this genocide was occurring, President Bush made a very conscious decision. Okay, I get it. We have philosophical issues about the ICC, but these people are being subjected to genocide, and we can't stand back. We have to do something about it. We can't just let this happen. And that was the issue that was front and center. You see the reverse of that in the Obama administration, where there was a predisposition, I think, for working with international institutions and working with the ICC. But even in the Obama administration, what you saw was support for the ICC sort of dried up at the end when the prospect of the prosecutor commencing an investigation of the situation in Afghanistan was looming. She said, the prosecutor said at that time that an investigation was imminent. And you saw, even before President Trump came in, you saw the sort of pulling back. The task force's mandate in 2000, for the last transition, was to come up with pragmatic recommendations. And the emphasis was always supposed to be on pragmatic. And so the task force did a couple of things. First, it had a long list of things that, the reference of which was, whatever you think about the ICC, these are things you should be doing. You can support accountability regardless of whether you support the ICC. There are other ways to support it. There are you can build accountability and justice into the president's national security strategy. You can follow the court's jurisprudence, even if you don't like the ICC. It's important what they're doing, as opposed to just sort of ignoring it. So stuff like that was the right thing to do, sort of no matter what your overall perspective was. And those things remain relevant today, I think. But there are other things that you can't do unless you have sort of the political oxygen to do it. And that's what sort of dried up when the prosecutor moved towards an investigation of the situation in Afghanistan, which would have included allegations about torture during the early years of the Bush administration in Afghanistan. And it was kind of a political reality that there wasn't going to be enough political oxygen in the room to have a really strong relationship. Excuse me. When the Biden administration came back in, there was a kind of dance, right? The Trump administration had imposed sanctions, and President Biden, after some struggle, it seemed like from the outside, lifted the IEEPA sanctions in April of 2021. And what that did was create sort of some space for the prosecutor to find a way forward without blatantly appearing to cave to the United States. The sanctions had this reverse psychology effect of making it very hard to accommodate the United States, and making it very hard for our allies to support the United States, to sort of weigh in on our side. So that first step by President Biden in removing the sanctions was, in my view, critical. And then in September, I think it was, the prosecutor announced that he would deprioritized the part of the Afghanistan investigation that encompassed allegations of torture against the U.S. And that's what created political oxygen in the Biden administration to improve the relationship. And then something else moved to center stage, which was the Russian invasion of Ukraine. And all of a sudden, this made the ICC, which was pursuing investigations of Russian atrocities, that made the ICC sort of wildly popular all of a sudden in the U.S. and including in the Congress. And it clearly created lots of political oxygen for a positive relationship. And we saw that Congress actually enact legislation to promote U.S. support for the ICC. And we saw things like Senator Graham sponsoring actual legislation. And he famously said that that Putin, through his invasion, had done what would have seemed impossible to convince Republicans to support the ICC, Republicans and the American people broadly to support the ICC. So that was kind of the political zenith or the zenith for political oxygen. And then the issue that came to the fore, it had been lurking, but the issue that came to the fore was the investigation of the situation in the state of Palestine, as the prosecutor calls it. And our task force report had said that it was inevitable that the trajectory of the U.S. relationship with the ICC would be shaped by how the situation in Palestine sort of developed. And it was already sort of leaning in a bad direction back then, but it really obviously just became an absolute center stage issue. Maybe was probably because it was an election year, but would have been terrible anyway, and robbed the administration of almost all oxygen. This is the Biden administration of almost all oxygen. And you can just agree or disagree that should be so, but that's the way it sort of works. And where we stand, and you could, and where we stand now is, unless this somehow can be resolved in some way, I'm not exactly sure what resolve means, the U.S. relationship with the ICC is going to be in for some rough times. And of course, it's going to be rougher than it would have been because the Trump administration is unlikely to give, in my opinion, as much weight to those factors that push you towards a positive relationship with the court than might have been true in a different administration. Working with international partners might not carry as much. The need to work with international partners is probably less important in a Trump administration with sort of a transactional foreign policy than it might be in a different administration. So factors that might otherwise galvanize support for the ICC or a lessening of the harshness of the reaction to the ICC are not going to be as present. It looks like they're less likely to be lined up on Ukraine's side, right? Which created a lot of the pressure for a lot of the oxygen in the last couple of years before the Palestine investigation. They probably are less inclined to give weight to the long-term kind of benefits, like the promotion, in the abstract, the importance of promoting justice and accountability. It'll come back, but they're less inclined. President Trump is probably less inclined that way. And honestly, they're probably more inclined to be sympathetic to claims that senior government officials should be immune from prosecution, because that's what they think here. That is likely to resonate with them, or may well resonate with the president. And so, you mentioned at the outset, Federica, the sanctions, and I do think that is really the thing to watch. A version of which was passed by the House in the summer, I think it was, and it's still pending, because in a way, the objective of the sanctions legislation is to break the history. There's been the sine curve up and down of the relationship with the ICC, and the purpose of the sanctions can be seen as breaking that sine curve and ruining the relationship forever, right? Making it impossible to support the ICC. And the goal, I think, of at least some of its supporters, I think many of its supporters, is to break the ICC, to sort of choke the baby. And we'll see if that works. We can talk more about whether we think that what the prospects for that are. If it were me running the Trump administration, which of course it's not, I would, even with the goal, even if my goal were to break the ICC, I would still think twice about those sanctions. I still don't think it's a good idea, even for that purpose. I think the sanctions are just so draconian and so likely to be seen as draconian and so likely to be seen as anti-rule of law, that I think the chances are high that the result of them would be to rally countries to the court's defense. And we saw that in in the year 2000, and it may not quite be the same situation today, but I do think that they are so draconian that they are their supporters should think twice about the effect that they're actually likely to have on the way the ICC is seen by those who might otherwise be a little wary of what the ICC has been doing, honestly. So maybe I should stop there so we can get back and talk more about it later. But thank you very much for putting this together, and thank you for inviting me.
Well, thank you for those very enlightening set of reflections, and you've offered a lot that I want to circle back to. But let's first turn to Ambassador Williamson, because obviously we led the discussion by speaking about sort of U.S. relations with the ICC, their history, their rocky history, because that obviously we all expect to be a significant question the incoming administration will have to deal with. But let's use this opportunity actually to talk about what does happen when the U.S. is able to work with the ICC. So the case in point here being Ukraine. So I'd love for you to speak to that. But also, let's not forget that the ICC is not the sole site of accountability. And again, Ukraine here is is the chief example, perhaps, that we have currently on the world stage of how regional, international, and domestic institutions can mobilize to deliver accountability for mass atrocities. So, having been involved in the front lines of all of this, I would love for you to offer your perspective on these issues, Ambassador.
Okay, thanks, Federica. Thanks to Carnegie for hosting this event. It's great to take part in this discussion with my friends and colleagues, Pierre and Todd. I have to begin with an apology. Unfortunately, I'm going to have to leave early in order to attend a Ukraine-related meeting on Capitol Hill that arose in the last couple of days. So before I do depart, I want to share some thoughts and on the points that you raised, Federica, really through the prism of Ukraine on some of these issues. First of all, it might be helpful to describe what we're doing in Ukraine currently. I serve as the lead coordinator for the Atrocity Crimes Advisory Group, the ACA, which is a joint initiative of the US, EU, and UK governments to assist Ukrainian authorities in their investigation and prosecution of atrocity crimes. In layman's terms, the foreign ministries of these three governments serves as a board of directors for this undertaking, and I report up to them. Projecting downward, I coordinate our work on the ground in Ukraine, which is implemented by 5 non-governmental entities that I oversee in my role as lead coordinator. The lead implementing entity is Georgetown University, with which I'm affiliated. And what Georgetown and our 4 implementing partners do is deploy subject matter experts, prosecutors, investigators, analysts, and other specialists to Ukraine to work directly with our counterparts in the Office of the Prosecutor General, the OPG, and with other government institutions, providing them with advice, expertise, and support as they investigate crimes and build cases for prosecution in the Ukrainian domestic system. The vast majority of our Georgetown experts and those of most of our implementing partners come with extensive experience in international tribunals or in domestic systems where war crimes have featured prominently, places like Croatia and Bosnia-Herzegovina. What eventually became ACA began with an initial response just 1 week after Russia's full-scale invasion in February 2022. When I led a small team to the Polish-Ukrainian border, we started working on March 3rd, 2022, with the Office of the Prosecutor General. We've continued working very closely with them since that time. We continue to help them with real-time investigative and prosecutorial efforts, but also in trying to build structures and put in place policies that will be necessary to sustain their work for years to come. Right now, they have over 140,000 atrocity crimes cases on their books. This number will certainly go down. There's some duplicative reporting. There are crimes that are not war crimes that were classified that way that need to be reclassified. So I think the number will go down significantly. But even after that, you're still going to have tens of thousands of cases that have to be dealt with. And it is going to take them years, probably decades, to address these. But this effort is an example of something that was initiated by the U.S. This started as a U.S.-only effort. A month or two into this process, the EU came to the U.S., said, we would like to be part of this. And then it was followed by the U.K. And eventually you had a joint statement by Secretary Blinken, High Representative Borrell from the EU, then Foreign Secretary Truss from the UK, designating the ACA as the official mechanism of the three governments to assist Ukraine. But this was, as I said, really driven by the U.S. The U.S. is still providing the bulk of the funding for this. And in my role as lead coordinator is also an indication of kind of the primacy of the U.S. in this process. But as we look ahead at how the Trump administration might affect the work we're doing, I think it's important to underscore something I said a moment ago, and that's that our efforts are focused on support to the Ukrainian domestic system. So while we're obviously vested in the outcome of other accountability efforts like those underway at the ICC or the initiative to create a special tribunal for crime of aggression, we're ultimately not dependent on those outcomes. So to put this in context, Ukraine has actually presented us with perhaps the purest example of complementarity under which the ICC was envisaged to operate. This is something you referenced earlier, Federica, in your opening. But unlike mass atrocity scenarios that we've seen in recent years in places like Syria or Myanmar, where you had neither an international mechanism for accountability available or a domestic one because the governments themselves were complicit in crimes, in Ukraine, you have had both the ICC able to act and a robust domestic justice system that had the capabilities to investigate and prosecute crimes. The rationale behind the joint US, EU, UK effort in the form of ACA is that the vast majority of war crimes cases will have to be dealt with by the domestic system. And that's where we needed to focus our efforts. The ICC, with its global jurisdiction, has generally not prosecuted more than 4 or 5 perpetrators in any situation it's handled. So even if they double or triple that number in Ukraine, you're still left with thousands that will have to be dealt with by the national courts. The idea under which the three governments and the Ukrainian government has operated then is that the ICC will deal with the senior-most political and military officials, people like Putin, while the Ukrainian system will handle the rest. This distinction is critical in one respect, and that relates to troika immunities, those enjoyed by a head of state, head of government, or foreign minister. So as far as Putin is concerned, he cannot be charged in Ukrainian courts. Likewise, if a special tribunal is established, it will have limited jurisdiction. So again, the majority of work will fall to the Ukrainian system. In saying all of this, I'm not trying to denigrate accountability efforts through the ICC or special tribunal. In fact, I'm very supportive of them. But it's only to say that the work that is ongoing domestically, while complementary to those efforts, is not contingent on them. So from the perspective of the incoming Trump administration, the work that is underway in Ukraine, I think, lines up with their general preference, at least as expressed in the first term, for pursuing justice at the national level rather than through international processes like the ICC. Presumably, this support from the USG to the Ukrainians will not be impacted significantly, no matter what happens with the administration and its approach to the ICC. But I think with a few caveats. First, it seems likely that we're not going to see any more supplemental budgets for Ukraine. I think this would have been the case even had Harris been elected as well. So we will probably revert to pre-war foreign assistance levels for Ukraine, at least outside the military context. And so this may impact the work that we and others are doing. Second, whatever happens in terms of funding could be impacted by a radical shift in the policy approach that the new administration takes toward Ukraine. Conceivably, they could say all assistance efforts toward Ukraine would be terminated, regardless of Congress's willingness to continue funding them. If this occurs and the U.S. unilaterally disengages, efforts by the UK, EU, and others could still continue. And frankly, I think this is an unlikely scenario. I think that there will still continue to be some support for Ukraine. For the very least reason, just to bolster Ukraine's position in any peace negotiations that the administration will pursue. Which brings me to the third caveat, and one that would be the most far-reaching in terms of impact. And that's a decision to include as part of a peace process some sort of amnesty at the national level for Russians accused of atrocity crimes. At the end of the day, I think this would be a tough sell to the Ukrainian people. President Zelensky has talked about the importance of accountability. Expectations have been raised. And it would be tough for, I think, Ukraine to sign off on this. But we can't completely rule it out. If this issue arises, it would again trigger discussions of the peace versus justice conundrum that we're all very familiar with. In my mind, and kind of going back to Pierre's point earlier, there really is no conundrum. There's justice is critical to peace and any long-term stability. So while everyone has come around to the idea, pretty much everyone, I think, has come around to the idea that any negotiated peace for Ukraine must include ironclad security guarantees to avoid renewed conflict, I would argue that a total abandonment of justice and accountability would also trigger, would be a trigger for renewed conflict down the road, as people would seek redress for their grievances through violence. We've seen this play out in other places around the world. And I think the stronger argument is for ensuring that some mechanism for accountability be retained as the administration looks for a comprehensive resolution to the conflict. Finally, in this regard, no matter what might be decided regarding amnesty within the domestic system, the ICC would not be bound by those decisions, even if the Ukrainian government decided it did not want to pursue or cooperate with their prosecutions. It would, however, make things much more complicated for the ICC. And so this is a good segue to how the Israel-Palestine case at the ICC might impact Ukraine. Todd may reference this a little bit, just to kind of expand on this some. As we all saw earlier, the ICC's investigations into Ukraine were well received in Congress and by the Biden administration, even as Todd mentioned, with the adoption of legislation allowing U.S. cooperation with the court. That goodwill was relatively short-lived and was completely upended by the ICC's issuance of arrest warrants against Netanyahu and Gallant. And whether you support the ICC action in issuing those warrants or not, the political reality is that the ICC support in Congress has almost totally disappeared. And even the Biden administration has been scathing in its criticism of these cases. EU governments, which have generally tried to maintain a supportive position on the ICC, have also been quite critical. And we now hear some of them questioning the ICC's authority to circumvent head of state, head of government immunities, as is the Biden administration. And as Todd says, this feeds into the thinking that we would anticipate within the Trump administration. So this latest permutation could impact the ICC's work on Ukraine if it gains traction, even if EU governments remain broadly supportive of the court's investigations in Ukraine. In the U.S., I think it is going to be very hard, at least in the near term, to salvage any sort of cooperative relationship between the USG and ICC. We almost certainly will see sanctions imposed by the Trump administration. I agree with Todd's concerns about those sanctions, but I think they are very likely. Ultimately, the U.S. is not a state party to the ICC. So even if the USG declares open warfare on the court, I mean, these cases are going to still proceed, even if EU member states who are states parties say we don't like what the court's doing. The court is independent to continue with its work. But I think it creates a climate which makes it very difficult for the court to operate, compounded by the current allegations that are out there against the ICC prosecutor. All of this makes its work harder. And so it is going to be tough, I think, for it to play maybe as quite a positive role as it could have without all of this going on. Finally, before I close, I want to touch briefly on the initiative to create a special tribunal for the crime of aggression, which has been proposed for establishment in The Hague. Another thing you mentioned, Federica. As you may know, the U.S. has taken a guarded approach to this initiative under the Biden administration. and has basically agreed to an incremental process beginning with the creation of an investigative prosecutorial body in The Hague, the International Center for Prosecution of Crime of Aggression. The idea was we would see how work went with this, and then would make decisions along the line as to whether the next step should be pursued, effectively creating a court. That said, there has been a lack of real consensus in the US government as to what the ultimate outcome should be. And some of the institutions in the US government, particularly among the defense establishment, the intelligence community, have expressed serious concerns about opening the door to crime of aggression prosecutions. If I had to guess going forward, I think these voices will likely prevail in the Trump administration, and it will be difficult to maintain even the go slow, incremental approach that the current administration has pursued. So I think this is going to make it more difficult for the special tribunal to be set up. It might be possible to establish a court without US involvement through Council of Europe or some other grouping of sponsoring nations. But a US shift from what has effectively been ambivalence to one of outright opposition may doom the effort. So in closing, I just go back to where I started, and that's to say that the efforts to support the domestic system in Ukraine and its investigation and prosecution of atrocity crimes probably holds the best prospect for success. Other than universal jurisdiction cases, which can be undertaken by third country governments, where suspects come into their custody either through travel or residence in those states, both Ukrainian domestic prosecutions and those in international bodies, whether it's the ICC or a special tribunal, will be hampered by the challenges of obtaining physical custody of defendants. Nevertheless, I would argue it's important to continue down this path of pursuing accountability, because as I said earlier, if you don't have some degree of justice here, we're setting ourselves up for renewed conflict down the road. So I'll end on that note. As I mentioned, unfortunately, I have to sign off, but thank you for giving me the opportunity to say a few words. Sorry to miss the conversation between Pierre and Todd. I know it'll be engaging, and sorry I don't have an opportunity to respond to any questions, but thank you so much.
Thank you, Ambassador, for joining us and for your contributions to today's discussion. We'll continue, maybe circling back to you, Ambassador Prosper, building on some of actually the very final remarks that Ambassador Williamson offered, which is if you don't have accountability, that is essentially sets the stage for renewed cycles of violence. And I think that this ties back with the opening that you offered at the beginning of the panel of the importance of accountability to international peace, to the global rule of law, and how these mass atrocities are threats to international peace and security. So if you would like to circle back on that, I'd love to offer you the opportunity to come back in. At the same time, since we have 15 minutes, and of course we could go on forever because there's just so much to discuss. But if anybody in the audience who's following would like to ask a question to our panelists, please feel free to forward them, and we'll make sure that they are received. Ambassador Prosper, over to you.
Great. Thank you. I mean, first and foremost, I think the Ukraine situation is essentially where we need to be. And to go back to an earlier question that you asked about initially the U.S. position on the ICC during the Bush administration, it in a way envisioned where we are today. And I was there obviously at the time, and I had the primary responsibility on this issue on what is the U.S. relationship towards the ICC. And we had two primary concerns. The first concern was what has been addressed here is the politicization of the process. And really, do you want to leave the issue of world order, if you will, in the hands of an individual, a prosecutor who can choose when and who he or she will prosecute, and that will have its own disruption. That was our concern. Obviously, we were concerned about the U.S. service persons, and we're concerned about the crime of aggression. As Clint just spoke about aggression, aggression was an issue that we debated during the Rome process and even after the Rome process. and could never come to an agreement with, because that was a fundamental issue that the United States in both Democrat and Republican administrations would really concern itself with. But the second, I think the more important issue of our opposition toward the ICC was the real question of, is this the right approach? There was such a push to internationalize justice and quickly move it as being the sole mechanism for dealing with these issues that really, as we put it and as I put it at the time, the concern was, and we are seeing it today in my view, is that there would be an abdication of responsibility by states. In other words, if you take the issue of justice and accountability and we wrap it around the security blanket that we just talked about, and you put it in the hands of one entity, the result is nations will just sit back and watch and say, well, what is the ICC doing? And this is in a way what you see with the Europeans who are parties to this, and other nations as well, whether it's dealing with Sudan, the Congo, pick your place where the ICC has exercised jurisdiction. Everyone has really sat back and really not much has happened in these processes. So what we advocated at the time, and I believe is the way to go, and we're seeing it in a bit with Ukraine, is we really have to rebuild, reinforce the rule of law at the local level, because it is the people who need to have the ownership. It will be the people who feel and breathe justice. It will be the people who believe in it and own it, and that will establish the fibers that will reinforce the security that we have talked about. Because if we leave it to an international mechanism, everyone has the luxury of saying, well, that was not our process. Well, the ICC failed, and you can be critical, as opposed to really rolling up our sleeves, doing the hard work that is required to build justice locally. And I think what you will see in the Ukraine process is, I don't really expect to see much out of the ICC, to be quite frank. But I think the efforts that Clint and others are doing to really promote the rule of law locally, regardless of whether the offenders are ultimately apprehended, but the fact that the people are involved and the people themselves are contributing and are saying, no, this is not acceptable, that will have the long-term lasting impact of justice that we really need, as opposed to an individual process that's 10,000 miles away from wherever, or hundreds of miles away, in the case of Ukraine, and the people don't really know what's happening, don't see it, don't breathe it, and don't feel it. Now, I could go on this, but I don't want to take up too much of the time. But I wanted to put that into context, and then when we come back, then I'll give you my views as to where I believe this administration is going and what the future may be.
Thank you so much, Ambassador. And I really appreciate and welcome your framing that really the priority should be to invest in strengthening the domestic rule of law and to ensuring ownership of the affected community, of the national systems, of these justice processes. And I completely agree with that. Although I will say also, and I think that, again, the case of Ukraine is evidence of that. Well, first of all, the ICC, I think it's important to acknowledge for our audience that the Rome Statute, the ICC is a complementary regime, which means that they can only step in where those domestic processes are failing or are not there. So the way really we should think, I believe, of the ICC is as sort of safety net, right? Of course, the priority should be in investing in those domestic processes. And I think that there's been a lot of progress over the last 20 years and more in that area, in many contexts, well beyond Ukraine. But I also think that it's not always possible, right? And so where those are not possible, then I think it becomes extremely crucial to have an entity like the ICC. And even in the case of Ukraine, Ambassador Williamson, there are things that the national courts simply cannot do. So in the case of a head of state or a defense minister or a foreign minister, a domestic court really would not be able to exercise jurisdiction over those three individuals. And that's where we're seeing in the case of Ukraine, and that's where the ICC step in. Vice versa, there are things that the ICC cannot do. We talked about aggression, and I wanted to circle back to that because the reason why there is a proposal for a special aggression tribunal is that the ICC cannot exercise jurisdiction over aggression in the case of Ukraine. And Ambassador Bopolt, you actually were the deputy head of delegation at the Kampala Review Conference, where the crime of aggression amendment were finally adopted. And you actually wrote, you were very critical of the provisions that were adopted at the time. I wonder if, fast forward to today, having seen what Russia's invasion of Ukraine and, this various efforts to create the aggression tribunals have led to, if you've changed your mind, or maybe if that's doubled down your initial skepticism. Ambassador, you're on mute.
Is that better?
Yes.
Okay. I think that's a great question. I think, if you sort of look at the two basic models, an international tribunal and a tribunal sort of embedded in the Ukrainian courts, I think an international tribunal is hard, if for no other reason that I don't think there's enough support in the General Assembly, and that it's really not clear to me that some kind of regional support would be enough to give the court the credibility, the international credibility that it would need. I'm also not entirely sure that it's not clear to me that the arguments that aggression charges against Russian leaders, if the court were international, I'm not really sure that that makes it in sync with under international law. I know that's a sometimes unpopular view, but people remember the Kampala amendments for the fact that it resulted in an exclusion of aggression jurisdiction over countries like us, nationals of countries like us that aren't Rome Statute parties, and like us and Russia. But even among the Rome Statute parties, the understanding was that there would be no jurisdiction for states that did not accept the aggression jurisdiction. There had to be consent. And the hard issue among the parties then was not whether there needed to be consent, but what would qualify as consent. Was the fact that you had consented to the Rome Statute in the first place, was that enough consent, or did you need specific consent to the amendments? But either way, the premise was that you needed consent of the state whose nationals you were prosecuting. And that just won't be there for Russia, right? That just won't be there no matter what. And I think inevitably the issue will get back to that. In the insofar as we're talking about embedding something in the Ukrainian legal system, I think beyond the questions about head of state immunity, just not sure, and that even if you had enough international support to make it credible in some sense, I'm just not sure it's the way to go. I remember, I think it was in the run-up to Kampala, having a discussion with one of the Russian lawyers who we used to talk to, who was very talented. They had very many very talented, bright, engaging lawyers. And I remember probably inopportunely coming up with the example of Russia and Georgia at the time. And if aggression, and I said to him, if an aggression charge is prosecuted in a Russian court, we know exactly how that's going to come out. And when it's prosecuted in a Georgian court, we know how that's going to come out. And what did it really, was that really the way to go? Was that sort of a credible path forward? I had my doubts. I guess one other thought I would share about aggression prosecution is that, putting some of the legal niceties aside, it seems that there is to me, that there's a question about whether an aggression prosecution against Russian leaders really sort of fits in with the kind of negotiated end to the war that we seem to be, towards which we seem to be headed. So just to say that in different words, it's sort of one thing to say in the midst of World War II that we're going to prosecute Hitler for aggression, or the German leaders for aggression. That made sense because it fit with an overall policy of unconditional surrender. But nothing like unconditional surrender seems to be on the menu of Ukraine. And so it's not clear how whatever is on the menu for Ukraine, it's not clear how an aggression tribunal would fit into that, and therefore whether it would be stable. So I guess my bottom line is I have qualms. I have. It makes me think a lot, but I'm not sure that I'm sort of doubtful that an aggression tribunal will ultimately happen, that it is ultimately sustainable.
Thank you so much for that. We've actually received a question from the audience, and I think it's important to ask because it is something that, I certainly encounter in my work a lot, and I'm sure both of you do as we engage outside of the United States about perceptions that the United States politicizes global justice, international justice, and the ICC. And whether the United States is in fact a genuine committed leader when it comes to accountability issues, because as the audience member points out, you have sort of two situations, right? Ukraine and Israel, Palestine, where neither Russia nor Israel being states parties, and arrest warrants are issued against the heads of state and defense ministers in both situations. In one case, the Ukraine situation, the United States government, of course, welcomed the development and supported the investigation. In the case of the Israeli arrest warrants, it's been quite the opposite. And I think that there is important legal nuances around jurisdictional questions that often gets, I think, lost in this type of framing of questions. But nonetheless, let me put the question to you, because I do think it touches on an important issue, which is that of hypocrisy, double standards. We hear a lot more of that. Whichever of you would like to take it.
Yeah, great. I'll quickly jump in. We only have a few minutes. I think there's hypocrisy and double standards across the board. It's not just the United States. What we have to keep in mind is when we're dealing with these issues of war and what happens in war, it's inherently political, and people will take sides, they'll take their approach. Even the Europeans, and this is my point about abdication, on one hand, they may be saying that they support the ICC, but do you have to ask yourselves, what are they doing behind the scenes? How aggressive, how strong are they on these issues? So accountability in a war context is inherently political, and people, even the ICC itself, will make a political decision, and that is the problem. So that is why I think it's important to try to find a way to bring these issues and localize them. There's no need, in my view, to immediately jump to an international process. There is a time and place for international process, but we don't need to jump immediately to it. And I'll pass it on to Todd.
You passed it on to me, but you've said what I would have said. I think that break the answer up into my answer up into a couple of parts. One, I do think there is a genuine strand of sort of American body politic that believes in justice. The fact is that there are other things that are believed in, and that sometimes they can end up outweighing. That's the whole. If you sort of think back to the Obama administration, which was the warmest the U.S. ever got towards the ICC, the mantra was, we'll support the ICC in its investigations and prosecutions that advance U.S. interests and values consistent with the requirements of U.S. law. That's what we would say over and over again. Well, that's to say, often, maybe, sometimes, maybe, but not always. And that comes at a cost. That comes at a cost of some amount of credibility, and but it's the best that's sort of imaginable when you're sort of talking about the context that we're talking about, with all the security and other interests that are at stake. And it's true that if you're a human rights advocate, you might say, well, in that case, we don't want your support. But that's the if there is going to be support, that's what's going to come. And then I would just expand for a second on Federica's comments about that there are nuances between the Israel situation and the Ukraine situation. It's true that both Israel and Russia are non-ICC parties, but in the Russia case, there's no question that Ukraine is an ICC party. So at least according to the Rome Statute, the court has jurisdiction. In the Israel case, though, from the U.S. point of view and from the Israeli point of view, there is not acceptance that Palestine's a state, and or at least in the nature of Palestinian statehood. So if you begin from that premise that Palestine is not a state or is not the right kind of state, then the fact that Israel is not a party is dispositive. So it is sort of a fundamentally different issue, and it's worth noting that if you read through the decisions that the court has made on the situation in Palestine, they still to this day have not said that Palestine is a state. They've said that they're sort of a state for Rome Statute purposes, but they've never said, they've never ruled. They've sort of decided that they don't need to rule on whether it actually has the powers that it would need to delegate to the court to be a basis for the exercise of jurisdiction. And from the Israeli point of view, there is not even the fact that Israel is not a state is fundamentally different in that situation than the fact that the fact that Russia is not a state party is in the Russia-Ukraine situation. I think I said that in a tangled up way, but hopefully I said enough of it so that it came through a little bit.
Thank you, Ambassador. Actually, thank you both. Unfortunately, we're out of time. Surely we could continue, but we have to wrap up here. I hope to be able to continue the conversation in another format, in another setting, certainly. And I really just want to thank you both, and of course, Ambassador Williamson as well, for taking this hour to enlighten us really with your insight and for sharing your reflection to the benefit of this discussion today. So thank you both, and that's it for today.
Thank you, Federica. Thank you, Pierre.